on behalf of Diado. Here, Diado is out of station, Lordship.
Item number 6.
Yes, Lordship. For medical purpose, Lordship.
It was a hearing matter of 2021. Na?
Yes, Lordship.
Who is out of station, you're saying?
Diado, Lordship. He's health ground, Lordship. Conducting council, Lordship.
Conducting counsel for applicant, appellant.
Yes, Lordship.
In number say D. Oh, dear.
Hmm.
And the request made by the other side is
I'm for state lawsuit.
for state.
I
And you
I
are
have
for the
taken
private
concern
respondent?
from ourselves.
I'm for the respondent side.
Private respondent.
Yes.
You are Mr.
T. Tamo. I on behalf of M. Bagra.
Ladies and gentlemen, so and so. The M. Magra is what is it? MI plus.
Yes.
The request made by the learned counsel for the appellant, the consent of the respondent. Let the matter be listed. How many weeks you need?
2 weeks, Lordship.
2 weeks. Let's start after 2 weeks. As only 2 weeks by the list. Blank.
DPW.
Your lordship, I beg to mention item number 7.
What happened with 7?
Lordship,
Your one
I'm
three
on-
is also there.
I'm on behalf of Titaba for the petitioner. Lordship, the matter may be fixed for after 3 weeks.
What is the problem? Why you need it?
Or the learned counsel is out of station, lordship.
Mr. Bitaba,
Yes.
you're for the other side,
Yes. For the private respondent,
private respondent. Government advocate is also there, and the council of RD. With the
consent has been obtained also.
consent is not, with the consent of the other side also for it. You want after 3 weeks?
Yes,
No.
lordship.
Deeply obliged.
Deeply obliged.
May I please, Lordship, I beg to mention item number 4. Leading counsel for the petitioner is out of station, my lord.
It is an order column, I think.
Yes, my lord. Lordship, I have taken consent from others.
It's okay. Let's see.
Yeah, madam, petitioner was supposed to file amendment petition, madam.
Yes, that's what I. So last occasion also you paid time for filing your amendment
Yes.
petition was there.
Yes, Lordship.
So it's not ready now.
Yes, Lordship.
Our consent with the others.
Lordship.
Conducting council is out of station
Yes, Lordship.
as who is he? See,
O Modi.
O Modi,
Yes.
stating that the conducting council, Mr. O Modi is out of station. Let the matter be listed accordingly after 3 weeks.
3 weeks.
After 3 weeks. Enabling the petitioner to file the amendment petition. You file amendment petition by that time,
Yeah.
after 3 weeks.
Yes. Deeply obliged.
Lordship, I'd like to mention item number 3.
Hmm.
The London CCC is out of station, so.
As
matter-
now. Who is out of station?
I'm for the respondent.
You are for the respondent.
Yes, I have obtained consent from the petitioner.
The other side, you have taken consent.
Yes, Your Honor.
You are paying for the other side. Same order.
The matter is fixed after 2 weeks. Highly obliged.
Yeah, please. Lordship, as per the direction of the last order, I have already served the extra copies to the respective respondents. Lordship, today, leading counsel, he could not turn up as he is out of station. Therefore, admission may be fixed on the next date.
Ah. Payment of some exam, yes. Yes. My brother is asking why these two matters are listed together, because these of, one is for payment and all, one is for outside.
Different, two different matters. Why listed together? Always. One is for regarding LPC, other one is for the payment of some additional work which petitioner has executed.
It's up to them which one to be paid.
No, is it a case that if the lawyers are same, it has to be listed along with
Both
that?
are, yes, analogous
Irrespective
cases.
of whether this is the
How,
listing or separate
that's why he is
matter.
asking how, why it is analogous.
Both are related to the same location,
Huh?
same location,
Same? Same location.
yes.
Item number 2 is encroachment.
Yes,
Regarding eviction and encroachment.
yes. Other one is for payment,
Payment,
claiming
payment,
payment for additional work which he has
Yes.
stated to have
Executed, yes.
executed. Anyway.
Can it be segregated otherwise?
Lord, I'm so sorry. I'm not aware about the facts and circumstances. Detailing my senior counsel, he will be aware.
As per the last order, requisite extra copies are to be served. Have you furnished the extra copies? For respond number 4
Yes.
is already furnished?
Yes. So in the item number 1, I am the formal party. The tourism and the RW is the main party here.
You are a formal party.
Yes. I am there, but I'm not.
Yes, do you have anything to say? He is Mr. Mauna. Yes. No, no, no. He is. Huh? Yes, Mr. Pala, do you have anything to say?
For responding number 2.
You are for the response number 2. Secretary, Department of Tourism.
Standing Council Tourism.
Yes.
What is your stand?
Pardon.
Are you admitting the execution of the work?
No, no.
But your affidavit says so. Your affidavit says he might have executed, but on his own risk. We're not liable to pay. That's your stand. And he's saying that after execution, as ordered by your authority, executive engineer, you are using the structures, whatever buildings or something. Tourism department.
Our stand is, my lord, execution must be there, but there was no authority on our part. We never authorized.
But fact remains that he has executed. You have to regularize and pay it, since you are using the structure which he has executed.
Utility also were denied. So we were allowed to file affidavit.
So one part you are admitting, that means. Execution of work part you are admitting.
Yes.
Utility part is different, other way. Anyway. then go to vice.
It can be segregated. On the same day that it can be segregated.
Yes, yes. Number 1 of the here, Hard Mr. Swens Dilanet counsel for the applicant, and also Hard Mr. and Father Dilanet standing counsel for Swens and Miss MS is the term number. In that for the
I am for 1 and 5.
1 comment advocate for 1 and 5. We are for 2.
Yes.
This submitted by Mr. Swenso that the youngest county to personal difficulty and his counsel, Mr. R. Sonal, is not in a position to here to one of the position to attend the court and accordingly paid for an adjournment. After perusal of the record, it is that the matter is relates to different subject and hence we do not find any necessity to tag the matter along with WA 12 of 2023. Matter may be segregated, however, matters may be listed together for convenience. Both the matters be listed together. Segregation kori diba? Do number is the same, GAPS. And the matter will be listed after 3 weeks, you want, or after 2 weeks?
3 weeks.
3 weeks?
Yes.
After 3 weeks, let the matter be listed after 3 weeks. It will be, we are not dead which, we have already segregated the items. It will be maybe listed together. It may be listed together,
Yes,
but
yes.
it will be segregated. The items. List after 3 weeks, both the items.
Lots of item number 2, we have filed our affidavit already. Item number 2 is.
Item number 2,
Yes, to this item number.
submitted by so and so that.
That's it, this may
item
be
number 2.
fixed after 2 weeks or so. Item number
He is
2.
praying for 3 weeks. If those two matters are listed together, in that case, it will be listed after 3 weeks.
Lots of.
In item number 2, you have already filed your.
And in item number 2, we are the only party, the original.
Yes, yes, I have seen. That's- Item number 2, they have already filed your affidavit. It's item number 5.
Item number 5.
Hmm.
Item number 5, IA number 8 is with regard to condemnation of delay in filing the affidavit.
What was the delay?
Ground, Lordship, I have cited. The ground for this condemnation is, one is, if the other property, poverty. The wife with this accused person wins,
Main ground is poverty.
the poverty.
Where you have mentioned your grounds? In
Parent,
Era 3.
and then thereafter I have filed this petition into. Criminal revision, but it was, there were some certain technical difficulties. It was withdrawn and again refiled in the form of this present appeal. So during the court, also time is second. Inclusive of all those, it is 120 to be condoned, that may be condoned.
So earlier you have filed one revision also.
Yes.
It was wrongly filed.
Yes.
Yes.
Your Lordship, notice was issued to the respondent number 2. It's a POXO matter.
Oh, yeah. Who is respondent number 3? In fact, the private respondent. Heard Mr. D. Patil, Learned Counsel for the petitioner, and also heard Mr. S. W. Learned Government Advocate, Senior Government Advocate for the respondent. Full stop. It is submitted by Mr. Patil that inadvertently he could not take steps on respondent number 3, though it was directed to him. Accordingly, he paid some more time to take steps on respondent number 3. Prayer allowed. So he is asked to take steps on respondent number 3 within 5 days. List the matter accordingly. After 3 weeks, after a week, will it be, it will come return, and it will be after 2 weeks then?
My lord, I beg to mention item number 21 and 22. This matter may be adjourned for today and I kindly list it after 17, my lord.
These two matters are in order columns. Why you need adjournment?
Yes, my lord.
These two matters are fixed in orders column.
Yes.
So why you need adjournment?
My lord, the leading counsel for this matter is having some health issue. So I have already taken consent from
Yeah,
the
my lord.
both side also, my lord.
Who
Yeah.
is T?
Talin Dukam Digya.
Huh?
Talin Dukam. Talin Dukam Digya, my lord.
Yeah, my lord. I am here for respondent, my lord.
In item number 21, you are for the respondent,
Yes, 21, 22, yes.
standing counsel.
Yes, my lord. So there is a interim order, my lord.
Interim was there.
Yes, my lord. Because of which we are facing some problem, my lord.
Interim was in your favor? Or
No, no, their favor.
Okay.
So they are, my lord.
So there was an interim order as per them.
Yes.
Otherwise, case is ready for.
Yes, ready, my lord. For, the state has filed their affidavit.
No, why it is in order column, in fact, for IA?
IA, yes. Let it be on 17, my lord. For final disposal.
Okay, for you. heard Mr. Swen, appearing on behalf of Mr. D. Regia. The council, conducting counsel for the petition. And also heard Mr. B. Picha, the non-standing counsel Ado. It is submitted by Mr. Swenso that due to the pray for adjournment stating that the leading counsel is out of station. The matter will be listed on 17th,
17 for admission hearing.
17/6 for admission hearing.
My
Item number 22, you are there, item number 22.
21
For R9.
Swenso on behalf of F. Swenso and Mr. MS and Langen. For the, you are for the respondent number
Respondent 9. 9.
9, for the respondent number 9, and Mr. Picha, you are
I am for the state, my lord.
state. Mr. O. Dangong is also there.
She is,
No, he's with me. Oh, Dugong is with me.
Oh, sorry. Sir. Both the matter will be listed on 17/6. So both the matters will be listed on 17/6 for admission column.
much obliged.
May I please, your lordship? Lordship, I beg to mention item number 11, lordship.
11,
Lordship. Lordship, in this matter, lordship, I have been newly engaged counsel, lordship. So I'm for the private respondent number,
this council for the
private respondent number 8, lordship.
private respondent number
8, lordship.
8.
So, lordship, this matter may, I'll go through with the records, lordship, and this matter may be fixed on 10 next week, lordship. 10/6/2022.
Who are for the petitioner side?
I have taken a
Consent.
consent as an opt-in, lordship.
With the consent of the side. Is there an option? So and so, appearing on behalf of respondent number 8. Na? He is appearing for respondent number 8. Respondent number 8, paid for an adjournment, stating that he is newly and his counsel and hence needs some more time to go through the record. Let the matter be accordingly listed. 2 weeks need? 10/6. List on 10.
My lord, may it please your lordship, my lord?
All, my lord.
May it please your lordship, my lord?
Yes, yes. Yes,
My lord, item number 24, I have 23, I have taken the counsel on the other side. Similar matter has been fixed on 10th of June.
in item number 23.
Yes, 23, my lord.
Yes, so I have taken
No,
the consent of the other side. Let it be fixed on 10th of June, my lord.
Will you be ready?
Lordship,
Okay, then.
Lordship, in item number 23, I'm representing R5, respondent number 5.
You're
So I've-
R5.
Lordship, I filed my wakalat number this morning. So I'm
You have
seeking,
already filed or you're going to file?
I have already filed a wakalat
Okay.
number and I'm seeking 2 weeks' time for filing affidavit. Lordship.
My lord, let
R5.
it come on 10th of June, my lord. All it is fixed on 10th of June. There is an IA which has been filed. So let it come on 10th of June.
Item number 23.
Item number,
23,
even
my
was there any interim and all?
23.
No, no, we are on 23 now.
Yes.
You are Mr.
AK Sahwal.
Heard Mr. A.K. Sahwala, the learned counsel for the petitioner, and also heard Mr. D. Das, the learned senior advocate through BC. And Mr. B, you're
I'm for Mr.
What?
Das, senior counsel. Das.
assisted by Mr. Vin Pichai, and also heard
And Anju,
and Anju, the
for respondent number 5.
correspondent number 5, who has already filed her Kalat Kama. Considering the, with the consent of the petitioner, the learned senior advocate, Mr. Das, praying for an adjournment. Release the matter accordingly on 10th of June. 10th of June.
I am deeply obliged. I am deeply obliged.
10/6, interim be continued till next date.
Obliged.
Okay.
Deeply obliged.
Lordship, I beg to mention item number 15. I, on behalf of Mr. C. Modi, my senior counsel, he's out of his station, so the matter will be fixed after some time.
You have taken consent of the other side?
No, ma'am. No, your lordship.
You have not taken
Consent
consent.
has not been taken.
May I please?
You should take, you're for the respondent.
Yes, I am for a respondent.
So what you're supposed to say? He is saying that Mr. C. Modi is out of station.
I have no objection.
You don't have any objection.
Yes.
You are Mr.
L. Kagum.
heard Mr. So-and-so appearing on behalf of Mr. C. Modi and also heard Mr. L. Kamal, the counsel for the respondent. It is submitted by Mr. So-and-so that the learned and this counsel, Mr. C. Modi, is out of station and accordingly to require an adjournment. The respondent raised no objection. List accordingly. How many weeks you need? How many weeks you need?
1 week.
1 week? 1 week.
Yes.
He will come
yes,
back.
fine. Yes.
List after 1 week. As on activity is by the list.
Right.
Okay.
Your Lordship, I like to mention item number 7. The leading from Guwahati.
Leading counsel, who is leading counsel?
B. Arun.
B. Arun.
Yes.
Okay, order to read. So he'll be available in the next week or 2 weeks you need?
2 weeks.
Do you need any fixed date?
No.
After 2 weeks?
Yes.
No, I'm asking because he is coming, he is from Guwahati.
Yes.
That's why I'm asking. Do you want any fixed
will-
date?
You will come after 7-8 days.
List after 2 weeks.
Lordship, I like to mention item number 8.
Hmm.
This matter may be fixed after 2 weeks.
Why?
I've taken consent from the petitioner side. Moreover, I'm from the Union of India. Moreover, DSG out of station.
DSGI.
Yes, M. Kathur.
Petitioner who is representing
Uh,
Mr. Tititar.
Titita, Jungam Jini petitioner. I've taken already consent from the petitioner side. And again, your Lordship, I like to mention item number 6.
Just wait. DSGI. Standing Council of Land Management was also there. Is there? No. The concept of the other side demanded that you are appearing for DSGI,
Yes,
Union of India,
yes, sir.
appearing on behalf of DSGI, Union of India, paid for an adjournment, stating that the DSGI, Mr. Who is DSGI?
M. Kathur.
And Katu is,
Out
M.
of
Katu is out of station. List him, you want 2 weeks or 1 week?
2 weeks, your Lordship.
List after 2 weeks.
And Lordship, item number 24. I've obtained consent from the petitioner side. Your Lordship. This matter may be fixed after 2 weeks.
34,
24.
3-4, 2-4, actually, sir. I thought 30. Now see, this is of 2019, in fact.
Was it?
This is of 2019. Same you are appearing for,
Yes, your Lordship.
this is a matter of 2019. So I thought that it should be heard actually. It's all pending one.
Lordship, otherwise, it may be possible for the day. Tomorrow matter may be fixed. Moreover,
Tomorrow most probably list is already there, tomorrow may not be possible. Okay, if you can, a good matter, if it can be placed on Thursday also, Thursday,
yes,
list on Thursday.
Hello, Lord.
Thursday is Piba. Huh? 6/6. It will be listed on 6/6.
yes.
My lord, I would like to mention item number 12. This matter may be taken up on 12th of this month.
Hmm?
12th.
12.
Yes.
Why you need 12?
Lordship, I have to.
Lordship, I am for a petitioner here, Lordship.
You're for the petition.
Yes, Lordship. Lordship, already opportunity was given, Lordship. Today was the last opportunity, Lordship. But still they haven't come up with the affidavit in opposition, Lordship. So, Lordship, it's a
Item
very
number-
simple matter
item
which
number-
can be disposed today itself on it.
Yeah. No, affidavit of opposition was supposed to file by the respondent.
Respondent, yes, Lordship.
Respondents.
Yes, Lordship.
So, you have not,
Not filed, my.
why not?
So 1 week time. So the matter may be fixed on 12.
Lordship, since I am the sufferer, I am suffering, Lordship. I just want 2 weeks industrial training from the 2 weeks industrial training, Lordship. Since Lordship, my promotion, I am eligible, as I am eligible now for assistant professor senior scale. So Lordship, since on 24th March, Lordship, I was eligible, Lordship. And this is June, Lordship. Since I am suffering, Lordship. Because if I wouldn't be like, if I wouldn't go for industrial training, then Lordship, I wouldn't be eligible for assistant professor senior scale level, Lordship.
Hmm.
So Lordship, if Lordship, this matter may be taken up today itself only, Lordship, because last opportunity was given, Lordship. Still, the respondent authorities have not come up with their affidavit in opposition, Lordship. And now
Yes,
they are
sir.
just asking
What
for
to say?
Lordship time.
So without affidavit, I cannot pay it, my. So
So
opportunity
he
may
is
be.
seeking it is to be fixed on 12, let it be 12
So
on 12, obviously
Yes.
matter may be heard. And
yes, Lordship, then fixed date may be given, Lordship. Fixed date may be given.
Fix it, he is
12,
seeking on 12th.
12, Lordship.
12th of this month.
Last opportunity, Lordship. After that, no more adjournment, Lordship.
We are on which item? 12. No? Item 12. Heard you are Mr. G. Jeni?
Yes, Lordship.
The learned counsel for the petition. And also heard Mr. You are Mr. T.
T got it.
T. Gade, the standing counsel of
Yes,
RGU.
yes.
RGU, and it is submitted that due to personal difficulty, the affidavit in opposition could not be submitted by him and hence prayed some more time to file their written by the affidavit in opposition. Accordingly, let the matter be listed accordingly on 12/6/2024, enabling the respondent to file the written affidavit in opposition. And endeavor shall be made to dispose of the matter at the stage of admission.
Highly obliged.
Lordship, I beg to mention item number 17. Lordship, we need some more time, 3 weeks time, maybe adjourn this matter.
For what?
Item number 17.
No, it is in order column.
Yes,
Why do we need an adjournment?
yes, we need an adjournment. And the petitioners want to file an IA. In the meantime, we'll file the IA.
You have already filed.
No. 3
Not
weeks
filed,
time may
filed.
be given. In the meantime, we'll file an IA. Consent has been taken.
One I is for what? 159?
159 was disposed of, my lord.
Disposed
of.
21,
Yes.
yes, ma'am.
Oh. Now you are going to file another I.
Yes, Lords. Lordship, 159 I was disposed of with a direction for payment for payment adequate compensation to the petitioners. But still, as of today, the payment have been not made to the petitioner.
Payment at all.
Yes, that's why we are going to file an IA. For that, we need some more time.
Order was dated, which order? Direction of payment was dated, which order?
21-24, my lord.
21.
Twenty-two 01/2024.
Okay.
You are Mr.
B. Kamdak.
Yeah, I think- Mr. B. Kamdak, the learned counsel for the petition, and also heard MS, your government advocate, right? Government advocate. So and so. Ki namaste kare. Right. How many respondents are there?
My lord,
Government?
consent have been taken from land department also, standing
Land
council.
department is there,
Yes.
government advocate Arunachal Pradesh. It is submitted by Mr.
Ah.
Kamdak that in spite of order dated 22/1/2024, till that no payment has been made by the respondent side, and accordingly they want to file an IA in that regard, and hence wants some more time to file the interlocutory application. Prayer allowed, enabling list matter. How many weeks you need?
3 weeks.
3 weeks.
Yes.
You are representing land department.
Yes, ma'am.
Mr. So-and-so representing land department. Need list matter after 3 weeks, enabling the petitioner side to file their interlocutory application in that regard. List accordingly after 3 weeks. Now 3 weeks have given you.
Yes.
File your IA within 3 weeks.
Deeply obliged.
Lordship, I beg to mention item number 9 on behalf of the standing councillor Tabat Agam.
On behalf of
Standing councillor Tabat Agam for the Department of Education.
Department of Education.
Education. Tabat Agam.
Tabat Agam, the Standing Council, Department of Education. And who is the petitioner side? Have you
We
taken
took consent,
consent?
yes.
With the consent of the so-and-so, the adjournment period on behalf of Standing Council Education, so-and-so. This matter accordingly after 2 weeks.
Right.
It will be listed after 2 weeks.
3 weeks.
2 weeks it will be listed, 2023 matter.
Obliged.
Okay.
My lords, may I mention item number 13?
Item number
13, my lords.
13.
Yes, ma'am. Yes, ma'am.
It's not reach, I think. You are for?
I am for-
No, yes, you are for, you are which one?
I am
I am for
petition.
item number 5 and 6, my lord.
5 and 6.
In item number 13, I am for a respondent on behalf of M. Khato, my lord.
Item number 13,
Yes.
for on behalf of MK to DSGI.
Yes, my lord. Yes, my lord. DSGI.
DSGI. So item number 13 was in admission column.
Yes.
Are you ready for that? Is the other side is online.
No, my lord. DSGI M. Khato out of station, my lord.
Huh?
My
Out of
lord,
station,
the
M. Khato.
reply has not been filed in the matter, my lords.
Okay. Now what you're submitting? You're Mr. Agarwal?
I'm Ketan Jain, my lords, for the petitioner. This matter has been led by Mr. Puneet Agarwal. He is my senior, my lords.
Acha. Okay, sir, you are appearing for him.
Yes, I am appearing for Mr. Puneet Agarwal. The reply has not been filed by the respondents, my lords, in the matter, and I also wish to say that this matter may be listed along with this main matter, WPC 552 of
No, that
2020.
order is already there. In fact, last occasion also most probably it was paid for. So this matter was asked to be listed along with along with WPC 552.
Of 2023, my lords.
You want to file any reply in that regard?
Yes, ma'am.
You, today, Mr. M. Katu is not there, no?
Yes,
M.
on
Katu
behalf
is
of M. Katu.
absent.
Yeah.
So he is appearing for behalf of M. Katu. So they need some time most probably for filing their written reply.
My lords.
Hard Mr. You are Mr. B.
Ketan Jain.
He, Mr. K. Jain, the learned counsel appearing on behalf of the engaged counsel, Mr. P. Agarwal, for the petitioner, and also heard Mr.
And Sora.
And Sora, the counsel appearing on behalf of M. Katu, the learned DSGI, and it is submitted that some more time is required to file the written objection. List accordingly. You need how many times? How many weeks?
2 weeks time.
2 weeks. List accordingly after 2 weeks.
My lords
Okay, it
may
will be listed.
My lords
Pardon?
may record that the matter be listed along with WPC 552 of 2023.
Yes, further it is
Directions
submitted
may
by,
be given to
okay,
registry.
further it is submitted that by Mr. K. Jain that matter may be listed along with WPC 552 AP 2023. This is a similar matter,
Yes, my lords.
similar matter. Registry will do the needful. Okay,
my
it will
lords,
be
the
listed
interim-
along with, yes,
Interim may be continued.
interim be continued till next date of listing. List accordingly 552, huh? Listen, Nikki. WPC 552 AP 2023.
Obliged, my
It
lords.
will be listed along with 552.
Okay.
Obliged.
May I please, my lord. My lord, I beg to mention item number 5 and 6, my lord. Can it be listed after 2 weeks, my lord?
Why? What has
My lord,
happened?
leading counsel M. Katu out of the station, my lord.
In both the matters, M. Katu is there.
Yes, my lord.
In both the matters, M. Katu is there.
Yes, my lord. I'm for the petitioner.
Okay, order put by M. Katu is there. So since how many weeks he is outside?
2 weeks.
After 2 weeks. Okay, it will be listed after. On
And-
behalf of M. Katu.
No, my name was,
Pardon?
no,
M. Katu is for the private petition.
yes, my lord, private.
Not as a strength of.
And my lord, one more item, item number 26, my lord.
Yes,
Yes, my lord, here also M. Katu is out of the station. 2 weeks time may be given.
he also, he is leading the leading council.
Yes, extending counsel, leading counsel.
Same prayer.
2 weeks time.
2 weeks.
Deeply obliged.
Lordship, Lordship, I filed this application for non-payment of the amount, which amount 44 lakhs 49,540 rupees, Lordship. Already this matter has been disposed of by this honorable court by the way of writ petition 561/2024 against the contemner. Moreover, the amount is still not paid to me, Lordship.
What is the amount?
Amount 44 lakhs 49,540 rupees. Lordship. This honorable court has directed to pay the said amount on or before 2 months. but still the 5 months has been lapsed. Still they are reluctant to pay the said amount. Moreover, we have taken a step by the way of providing letter on 14/12/2023 by enclosing the judgment order. And moreover, the reminder letter has been also issued to them, stating that the amount must be paid. But after expiry of 5 months, they are
Not
doing
paid.
as a official procedure. So afraid before this honorable court to issue a notice, or I may be allowed to take a justice service.
It is disturbed, you have, I mean, made party of the respondent number 1 as well as respondent number 2 in the name.
Yes, fine.
So though they are holding the post of, one is from Principal Secretary Finance
Yes,
and other is also serving as Secretary Finance
Yes.
and Planning.
Moreover, they were aware,
The order of WPC was dated
dated on
13/12.
13/12,
13/12.
2023.
Mr. Yes. You are Mr. M.
And Tangai Lordship.
M. Tangian? No, the learned counsel for the petition. This is an application on Article 215 for Constitution of India. Under section 1, under section 11/12 of the Contempt of Court Act 1971, read with provision of Contempt of Court Act, bracket or Guwahati High Court rules 1977. 77 against the willful and deliberate violation of judgment and order dated 13/12/2023 passed by this court in WPC 561/2023, 23, whereby the respondent was directed to pay rupees 44,49,540 within 2 months from the date of order. But even after expiry of lapse of 5 months, they have not filed, they have not paid anything to the petitioner side, and hence this petition. He further the next para, the learned counsel, Mr. So further submitted that they issued notice to the respective department as well as reminder also issued for the payment, but till that no payment has been made. Next para, issue notice to the respondent number 2 and you were Dusty
Yes,
to register AD and as usual process, and considering the prayer of the learned counsel for the petitioner, the Dusty service of the notice to respond number 1 and 2 may also be taken through Dusty mode and affidavit to file forward. List accordingly after 3 weeks.
Yes, please.
List after 3 weeks.
Highly
Take
available.
steps to Dusty as well as the registered AD also.
Highly available.
Middle
Yes.
pertains to impugn vacation order issued by the ADC SEPA under section 5 of the Council for the Public Premises Eviction of Unauthorized
Eviction order.
Eviction. So, this subject plot of land, it is measuring around 60 square meter, and it lies.
Have you approached any civil forum in that regard? No.
No, not yet. But we
But
have
it's a
been
case, maybe you can approach for the proper relief in civil forum also, there may be way. Otherwise, you are for the vacation order,
Yeah.
against the vacation order.
But impugn order has to be first. Impugn order first has to be towards because we have apprehension that subsequently an eviction order will be passed. So factual fact is this lane has been under my position since 1992 1992 So for more than 30 years. And it lies completely outside the boundary wall of the mini-segregated SEPA. My claim partially is it is also a private land. Because
Is it a private land? As
It is
per
my
your
claim.
claim?
It's my claim. Because as well as though I have also applied for allotment. in the year 2020. If
Allotment?
allotment. Maluk will find this allotment application at page number 21. Annexure 1 season. 20 almost. This 20 is Maluk, Chalan Maluk. But I paid in concern. 21 is the formal. But at page number 22, my lord will find at column 5, subclause 2, year of occupation of the plot 1992, my lord. And my lord, this was applied in the year 2020.
So as per you, the allotment was given you in 2000?
No.
Allotment order? No allotment order. is-
Not yet.
Oh, not yet.
There is still, my lord, pending. Therefore, my lord, I have one citation, my lord, of the coordinated bench, which says, my lord, until and unless, my lord, such kind of allotment process is not been, my lord, decided, my lord, either by granting or by rejecting, my lord, passing of eviction order, my lord, shall make my allotment process infructuous, and it will pose a legal prejudice to the petitioner. Citation is there, my lord. This is of 2019 for GLT 15. We'll find the operative portion at para 11 and 12. May I read over more this para 12. This code is in agreement with the submission made on behalf of the petitioner that if the impugn order comes into operation, the process of consideration of her prayer for allotment would not only be infructuous, but the petitioner will also suffer a legal prejudice inasmuch as the land in question has been stated to be under his positions for the last more than 11 years. Therefore, without taking a final decision on the prayer for allotment, the impugn action cannot be held to be justified, and accordingly the same is interfered with. Consequent upon the above discussions, this writ petition is allowed by setting aside the impugn order dated such and such, and the process elicited wide the notice dated such and such. It is also directed that the final order will pass on the prayer for allotment made by the petitioner by the appropriate authority in accordance with law.
Okay. Yes, miss. You're representing government.
Lordship, that is
1,
the-
2, and 3 or
Yeah.
1, 2.
Yes, that is their lordship. I agree and understand, but lordship, the just mere opposition does not give them any right to lordship get allotment. And then lordship, this is a petitioner has admitted already that this is commercial area lordship. The heart of the town, the mini secretariat, behind the mini secretariat lordship, district mini secretariat lordship. Everyone, if they just lordship forcefully occupy a place and then for the sake of claiming, everyone says 10 years, 15 years, 30 years, 40 years. Everyone says so. Whereas the petitioner himself is only somewhere 22 or 23, 1999 born. Lordship. So just because they are in occupation doesn't give them any right. Lordship. And he had applied only into 2020 or 2024. Lordship. Lordship. So I pray that lordship, since this is commercial also, occupying a commercial place without allotment lordship is lordship. And there is no illegality in serving them notice there. Lordship, with proper procedure, following the proper procedure, only the administration is serving them notice, lordship, and then giving them the time to lordship reply also, lordship. Lordship, I pray that this honorable court may not interfere, lordship, since the administration is following the procedure.
You want to file any written or your affidavit in opposition?
Lordship,
Or what
no,
it can be disposed of?
this can be disposed of, lordship.
Yes.
may kindly see this.
As per them, the proper procedure has been complied with.
My lord,
And
is also one
you
law.
have given the proper opportunity of hearing also.
No, my lord, no. Because, my lord, we have replied, my lord. So far, my lord, no hearing has been conducted. But we will find,
Hearing will be, they have come before hearing.
they have never
Yes,
fixed a hearing. They have never fixed, my lord. Only notice issued, my lord. To that effect, we have, my lord, so fixed. We have appeared, we have submitted our reply, my lord. But on hearing date, my lord, that is not yet been done.
That will be lordship.
My lord, can you see this, this annexer 7 at page number 34, my lord. We have replied. Page number 34. It was submitted on 13 May 2024.
So your reply is at page number?
Yes, ma'am.
Page number 20?
34 months.
34.
34.
Hmm.
This is, my lord, in reply to the notice dated 7th May 2024. We have 13 May, we have replied. No hearing is made. But, my lord, thereafter again, this impugn order, which is at page number 37. Ma'am. Impugn order is at page number 37.
Yes.
Page number 37. So, my lord, this impugn order has been issued to petitioner number 1, ma'am. But, my lord, allotment has been processed by petitioner number 2, ma'am. And there is, my lord, existing trading license in favor of petition number 3, ma'am. As well as, my lord, NOC issued by the UD department SEPA. It has been annexed, ma'am, in one series. So, my lord, in pursuant to this impugn order, my lord, we have also submitted this representation letter dated 27/05/2021, which is at page number 38. So, this has not yet been, my lord, disposed of yet. Neither any hearing has been conducted. And my lord will find this annexer 10 series, page number 42, my lord. This photographs. In the subjective name, my lord, we have erected SPT type building, commercial, consisting of 4 rooms. But it lies completely outside the RCC wall of the media secretary component.
What's the?
My lord can see the this GPRS map at page number 44. My lord, these are the wall, my lord. This subject building is here outside. And it doesn't create any kind of hindrance to the right of way of the public.
It is still government land.
That has to be, my lord, first decided first.
It's still government land.
It has to be decided. Because, my lord, this impugn order, it only says we have erected, my lord. But, my lord, technically this impugn order should have been issued under section 7, my lord. It has been issued under section 5, my lord.
There is nothing.
There is also, my
else.
lord, procedure left.
Section 4 has been already exhausted, Lord. After that, section 5 has been issued, Lord. If your lordship see page 37, lordship, here the impugn notice says that whereas notices were issued by so and so and so and so to so forth with relevant documents, but you have failed to respond since. So, lordship.
My lord, my humble understanding, my lord. My lord, when there is any kind of unauthorized occupation, my lord. Section 4 and 5 has to be invoked. But when a structure has been already completed, section 7 has to be. In this case, section 5 is. Therefore, my lord, I am completely remedialist. On secular fact of the case, my lord, I cannot go for an appeal. Therefore, my lord, at this stage, my lord, this impugn order is having to be set aside and passed. Because, my lord, there is issue of title. Adverse position, my lord. If assuming but not admitting, my lord. Therefore, my lord, at this stage, my lord, please, because they have given us 30 May 2024, the last time. But since, my lord, counting was there, yesterday there, but they couldn't put it. But I highly apprehend, my lord, within these 2-3 days, my lord, they will act upon this impugn order. Till then, my lord, at least stay of this impugn order.
Stay.
Stay.
Yes. Lordship, I'm not against this only this petitioner, but once this case given there, start constructing the proper building, concrete buildings. It has happened all the time. In every cases.
That condition
After
could be
30, let us go and say, they start constructing building this one.
that condition, if,
So,
my lord, that
Lordship,
condition, my lord, we are ready to abide with that condition. No,
You can dispose of the matter, I think. Instead of passing any order on stay, etc., matter can be disposed of at the motion stage, or is there any problem? At the motion stage itself, the matter may be disposed of, I think.
Yes, this was also saying that Lordship, his Lordship application may be considered a fund law, Lordship. With this, this can be disposed of. No, you're skipping it, Lordship. After stay, it goes on for 3-4 years, unnecessary.
We'll see to it if it's illegal or illegal notice, where a notice has been there. Have you given an opportunity of hearing and all? We'll see to it and then pass the order.
Opportunity to
So we're going to dispose of the matter today. Okay.
simultaneously, my lord, stay of this impugn order, my lord. Simultaneously.
No, if we have see the order, what comes, but we are going to dispose of the matter finally. If you want any more time, or do you want any? As per her, it may be disposed of, and as per you, the documents you have already placed with.
Yes.
So matter may be most probably unnecessarily wide should be there.
Yes.
So it may be disposed.
My lord, this item 3 and 4 are analogous.
Pardon?
This item 3 and 4 is
Similar.
similar.
Oh, it is similar matter.
Similar.
Yeah.
Item 3 and 4.
3 and 4.
Outside is mini secretariat, or not. Adjacent to mini secretariat.
Mini secretariat.
Yes.
No, we are on item number
2.
2 and 3 are same.
2, 3, 4, same.
2, 3 and 4 also same.
Same.
You all have there the commercial land. You have all.
Yes.
You're occupying the land.
Yes.
Some are from all are from 1992, or is there any difference?
Some are from 1990, some are from 1992, some are from 1994.
You have already specified those things?
Yes, ma'am.
These are structures are all structures are outside the mini secretariat.
Yes, adjacent to mini secretariat.
Adjacent to. Okay.
Declose.
Oh, vice.
So, chamber of reading. We are on item number 10. 10.
We have received our instructions, my lordship. We'll be filing an affidavit.
You'll be filing affidavit.
Yes, my lordship. We need some more time.
Education, apart from education, is there any other government department?
Item 10, it's
Forest.
forest.
Forest. Oh. Education as well as. No, only education department is only there, I think.
No, Manoj, it's forest department.
Forest. We are on item number
10.
10. Forest department also there. Forest department something. You are the standing council of education,
No, Manoj.
forest. No, you are government,
Government.
government, sorry. You are Mr.
T. Nima, Your Lordship.
and Mr. T. So and so. Appearing on behalf of the petition and also heard MS Sangeeta Asmili. You are Ms. T. Wamo, the learned government advocate appearing on behalf of your behalf of respondent number 1.
All the respondents.
All the respondents, all the respondents. And it is submitted by her that she needs some more time to file their affidavit in opposition. This matter, how many weeks you need?
3 weeks, Manoj.
3 weeks. This matter accordingly after 3 weeks, enabling the respondent to file their affidavit in opposition. Okay, it will be listed.
Leave the Lordship. May I please, my lord?
Yes.
My lord, I appear on behalf of DHJ M. Kato, my lord. Due
You are
to
appearing on behalf of?
DHJ M. Kato, my lord. Due to some personal difficulties, he
M.
was.
Kato?
Yes, my
Oh,
lord.
acha.
For respondent, my lord. All the respondent.
Otherwise, matter is ready. It can be listed for admission hearing.
Yes, my lord.
You are Mr.
Jeet hai, Lordship.
And after whom sent?
Lordship, through VC
Oh,
connecting.
acha. Okay, okay. Yes, yes. Yes, Mr. Sakya.
My lord, we have challenged the NIT for the very reason that part of the work which has already been executed by us pursuant to an earlier NIT, that has been included. And secondly, the works which I have already executed, that is not measured. So therefore, in another repetition, an order has been passed directing the BRO to have a joint verification within a period of 3 weeks. Considering all the facts of the case, by order dated 25/2024, the court has declined to interfere with the proceeding with the NIT on the ground that that may delay the matter. But today was fixed for filing of the affidavit by the respondent so that matter can be disposed of before the final results of the tender notice comes out. That particular portion does not reflect in the order method. However, since today is fixed method, I pray that the BRO may be directed to file their affidavit within a period of 1 week. And thereafter, my lord, at a shorter date, the matter will be fixed for final disposal because interim order has been negated by this honorable court. Although, my lord, the process has not been finalized as yet. So I pray that by if they file it by 10th of this month, in that case, matter may be fixed on 17th so that entire matter can be disposed of on 17th.
Yes,
That is my
Mr.
prayer.
Yes, what you say.
Okay, my lord. And,
You can file your affidavit by 10th of this month. Mr. Sakya is saying,
Yes.
in that case, it may be matter may be listed on 17th.
Okay, my lord.
Because interim is not there.
Okay.
That's why. Mr. Katu is absent today most probably, so
Lordship.
we are giving him time for 1 week or let it be on 10th of 6, 10/6, within 10/6,
Lordship.
if affidavit, then that can be listed on
17th.
17th.
Lodge. And for observation for disposal of the matter. Otherwise, my
Yes.
repetition would become infructuous.
Okay. Heard Mr. P.J. Sakya, the learned senior counsel, assisted by
Jeet hai.
G. Time, so for the petitioner. and also heard M. Choran
and Sora.
and Chora, the learned counsel, appearing on behalf of Mr. M. Katu, learned DSGI, and it is submitted that Mr. Katu is out of station and hence he needs some more time to file the affidavit in opposition. Full stop. In this context, Mr. Saikia, the learned senior advocate, was submitted that as there is no interim order in the case and hence his matter may become infructuous if some more time is given to the respondent side. However, he submitted that matter may be listed on 17/6/2023 to 24, and the respondent may be directed to file their written affidavit in opposition by 10/6/2022. Next, para considering the submission made by the learned counsel for both sides and the urgency of the matter, let the matter be listed on 17/6/2024, and with a direction to the respondent side to file their affidavit in opposition by on or before 10/6/2023. To stop further, the endeavor shall be made to dispose of the matter in the admission stage itself.
Obliged.
Okay.
Obliged.
Deeply obliged.
Item number 16. Item number 16. Here to petitioner is absent.
Yes, ma'am.
On the last occasion also, one Mr. D. Saikia was there for the petition. So the other department have also entered their opinions or not yet?
I am for 1 and 3, my lordship.
You're for 1 and 3. You're for 1 and 3. 2 is the land management. 4 is most
Right.
probably private respondent. None appears on call for the petitioner side. However, heard MS D. Wamu, the learned government advocate for the respondent number 1 and 3. List the matter accordingly after 2 weeks. Item number 18 and 19. Yes.
Lordship, I'm for the petitioner and we are yet to receive the affidavit in opposition.
Affidavit, as per office note, affidavit in opposition is not yet filed.
Yes,
You are going to file the affidavit in opposition.
my lord, I am for respondent in item number 18, I am for respondent number 5 and 4 and 5, private respondent. Basically, here it is the
In item
affidavit
number 18, you are for the respondent number 4 and 5.
4 and 5.
Private respondent.
Yes, yes. And
Yes.
it is the commission, state commission whose affidavit is to be required.
You're for 4 and 5, na?
Yes, in 18, 4 and 5.
And you are appealing for 1.
One. In item number 18, I'll be appearing for respondent number 1.
1. So you're supposed to file the affidavit in opposition?
No, ma'am.
You have already filed.
We won't be filing, ma'am.
You are not be filing.
No.
So most probably you are.
I'll file after filing after the commission once they file. Otherwise,
After commission.
yes, yes. case is order passed by the commission, state commission, information commission. So basically it is the main, state commission is the main respondent who is supposed to file it.
It did not become.
Lordship, may the interim order be continued till the next date of listing.
Was there any interim?
Yes, interim order.
You are Miss
Miss T. Mosang,
T. Mosang, the learned counsel for the petition, and also Hart MS T. Wampu, the learned government advocate, representing the state respond number 1. And Mr. Kaushik, your
No, T. Omo, T. Omo.
T. Omo.
Yes.
T. Omo, appearing on behalf of Mr. Respondent number 4 and 5. However, from the office note dated 1/6/2024, it is seen that the affidavit in opposition is not yet filed by the respondents. In that context, MS Iwamo has submitted, the government advocate has submitted, they are not going to file any written affidavit in opposition. And the counsel for respondent number 4 and 5 submitted that the affidavit in opposition will be filing by respondent number 4 and 5 only after the affidavit in opposition by respondent number 2 and 3, the commissioner. Release the matter accordingly after 2 weeks, enabling the respondents to file their written affidavit in opposition. Written affidavit in opposition. Till the next date of listing, the interim order be continued. Okay.
Obliged, Lordship.
Both 18 and 19 के order होगा.
May please, Your Honor.
2 weeks. Item number 23.
Your Honor,
Yes.
my senior, Mr. Mukherjee, is out of station today, Your Honor. This matter may be fixed after 4
He
weeks.
will be dealt with the case.
Yes, Your Honor.
Mr. Patin will deal.
Mr. Purdy.
Hart MS good
T.
name.
Y. Bhutia.
Bhutia, the learned counsel, appearing on behalf of Mr. T. M. Patin, the senior advocate, and submitted that the Mr. Patin is out of station and accordingly paid for an adjournment. To which the learning government advocate raised no objection. Please the matter accordingly. You will need how many weeks? Since till when she, I mean, up to when she is out of station?
After 3 weeks, Your Honor.
After 3 weeks. List accordingly after 3 weeks. Go for the hearing because it's 21 matter, no?
Yes, Your Honor. Deeply obliged.
My pleasure, Your Lordship. Your Lordship, the leading counsel is in lag in court number 2. This
Who is
matter
your
may be
leading
taken up
counsel?
If they come together. This matter may be taken if possible after lunch.
At 2?
Yes. What?
Or you have any urgency?
After 2 weeks, my lord.
Huh?
After 2 weeks, my lord. No, Your Lordship, because the leading counsel, they come to, will be arguing this matter together.
He is seeking that it may be fixed at 2.
Right, my lord. After lunch.
Yes. Huh? And do you have any objection? You have private, you are the private respondent, otherwise? Mr. Bicha is smiling and saying that it may be listed after 2
Otherwise,
days.
my lord, there is no urgency, my lord. There is an interim order in favor of dear my lord.
No,
There is status quo order, my lord. So there is no urgency, my lord.
There is urgency, Your Lord. Because the leading counsel is trying to argue this matter since last week. Last week, Your Lordship. This was listed in court number 2 before. But till now,
No, that can be understood. That is not the issue. Just I'm asking you if it is urgent as per you, or if it is necessary, we can hold at 2.
yes,
It's
Your
okay.
Lordship.
Okay,
After lunch.
okay, then? Okay. At 2.
Give you a blush.
It's a power of attorney holder.
Yes, my lord. My lord, there was NIT
for supply of some materials for Mahatma Gandhi National Rural Employment Guarantee Act for Damin Circle in the district of Kurunkume. The petitioner, being qualified, a qualified contractor, has also participated in the NIT. Thereafter, the NIT NIT, my lord, that was supposed to be this declared on 5/12/2023, but it was postponed due to some reason. The opening of the NIT was fixed on 5/12/2003, but subsequently it was postponed due to some reason, and it was postponed to 6/12/2023. And thereafter on 6/12 also, it was not open. And the next date for opening was fixed on 11/12/2023. Now thereafter on 11/12/2023, my lord, there was a board proceeding. And on that board proceeding, my lord, the respondent number, private respondent, was declared to be the L1. We both, the firm participated, and respondent numbers, this private respondent was declared L1. And thereafter, my lord, I have applied the NIT copy of both the respondent and of myself, and that was furnished to me on 27/12/2023. My lord, since it was voluminous, it took some time to compare this price rate prescribed offered by the respondent and myself. So since it was voluminous, so it took relatively some time. So thereafter, after proper cross-checking of the NIT submitted by both the parties, the petitioner found a glaring discrepancies in calculating the rate offered by private respondent number 3. Now that discrepancy, my lord, may kindly come to page number 27, my lord, annexure 2. Oh, sorry, 6, annexure 6. Page number 27, my lord. My lord. Now, my lord, this is the RTI reply, my lord, page number 27.
Reply.
Yeah, reply. This is by one year Nangram logo APO of this RD agency, Kurunkume. And next page is the, my lord, comparative statement of both the power. My lord, on the technical sanction copy, sorry, this is technical sanction copy, my lord. My lord, may kindly come to serial number 9.
Yes.
My lord, this is the technical sanction. Serial number 9 is CIB, my lord. CIB, IB full form is, my lord, Citizen Information Board. My lord, may kindly the quantity, how much of quantity it was to be supplied, it is 24 number. And the rate prescribed by the department, it should not go beyond 7,626. And total amount is given in the last column, my lord. Now, next page, my lord, page number 29. Page number 29, my lord. This is the comparative statement of both the firm, my lord. On the left-hand side, my lord, this is the price offered by Pacho Enterprise, my lord. Private respondent.
Which one? Private first.
Yes, on the left side. On the right side is the petitioner's
Yes.
price offered by the petitioner, my lord.
Mhm.
My lord, may again see serial number 9. CIB.
Mm.
That quantity, it is correct, my lord, as given in this previous page, technical sanction. Quantity is 24, it is correct. Now, next column, my lord, rate, my lord. This is the price prescribed offered by the private respondent. For one number of my lord CIB, he has offered 10,000.
Hmm.
Therefore, my lord, the quantity, total quantity into the price offer, it comes to 2,40,000, my lord.
Hmm.
It is correctly given here, my lord.
Hmm.
Now, my lord, may come to the price offered by the petitioner, my lord. On the right hand side, same serial number 9. Serial quantity is 24, my lord. I have quoted 6,863, my lord. And the total amount I have quoted for this particular item is 1,64,712 rupees.
Hmm.
Now, my lord, there is so many discrepancies in all these items, but I am just emphasizing on this item, my lord, because this is the whole case I have, my lord. Now, my lord, let us see in the bottom, my lord, the price, total price quoted by the private respondent number, private respondent is 215, that means 2,15,41,860, my lord. Now let us come to, my lord, this right hand side again, my lord. This is the total price quoted by the petitioner, my lord. 213,27,346, my lord. So, my lord, as per this document, since this document is the document that was supplied to me by the department, my lord, as I have applied through RTI, and on response to that, this document was furnished to me by the department. Now, my lord, the price difference, my lord, now is 2,14,470. Meaning thereby, my lord, I am L1, my lord, petitioner. He has offered less price, that was as against the private respondent, my lord. Now, my lord, after this, my lord, despite there being the petitioner being the lowest bidder, my lord, instead of awarding me the work, my lord, the respondent department has declared private respondent then to be the lowest bidder, my lord. Now, my lord, come to Annexure 8, my lord. That is at page number 72. This is the LOA. This is, my lord, this letter was issued to Basho Enterprise, respondent, private respondent, my lord. Despite I being the lowest bidder, my lord, I was not awarded the work, saying that the private respondent is the L1, my lord. That was only the basis that he was awarded the work, my lord. Now, how this has happened, my lord? Now, my lord has seen, this is the LOA, letter of acceptance, my lord, at page number 72.
Now, after this letter of acceptance, my lord, there was agreement. Agreement was drawn in between the authority and the private respondent. That is at page number 73, my lord, 73, 74, NH 9. Thereafter, my lord, when this LAO and this agreement had already been drawn in between the parties, my lord, the authorities and the private respondent, my lord. Having detected the discrepancy, my lord, I had filed one writ petition, my lord. While the writ petition was being taken up by this honorable court, my lord, my friend, the counsel for the department, my lord, he has placed one new document, my lord. That the document was not impugned with writ petition, my lord. That new document was the supply order, my lord. Till the filing of that earlier writ petition, my lord, that supply order was not issued to him. But during the pendency, it was issued to him. So therefore, since I could not impugn the supply order, my lord, writ petition was withdrawn.
But
And
during
because-
the pendency of the writ petition, supply order was also given to him.
My
Supply
lord,
order was-
yes, my lord. So since this supply order is not impugned in that writ petition, my lord, that was withdrawn, my lord, because there came up one fresh cause of action, my lord. So therefore, after wording that writ petition, this subsequent writ petition has been challenged, filed, challenging the LAO agreement and as well as this supply order, my lord, which otherwise was not put to challenge in the earlier writ petition. Now, my lord, how and why I am saying that there is a discrepancy, my lord, that, my lord, can be seen from the document submitted by the private respondent. Now, my lord, now come to page number 34. My lord, this is the deed document, my lord, submitted by private respondent, my lord. Page number 34, my lord.
Yes.
Now, my lord, the same serial number 9, my lord. The item to be supplied is CIB, my lord. This is the document of private respondent, my lord. Now, quantity he has given 24, my lord. It's serial number 9, my lord, at page number 34. First column is serial number, then CIB, my lord. The name of the item is CIB. Unit in numbers, then quantity, my lord. This is 24. Now, rate in rupees, my lord. 1,000 rupees, rate in words, my lord. Rupees 10,000. Sorry, this is 10,000, my lord. And rate in word, it is 10,000. Rupees 10,000 only, my lord. Now, this is the rate, my lord, quoted by private respondent. He has quoted rupees 10,000 per number of CIB, my lord. Now, surprisingly, my lord, come to the amount in words. This is, he has given 24,000. Instead of this 2,40,000, he has written 24,000, my lord. So therefore, my lord, since he has offered to supply this particular item at rupees 10,000 per number, so therefore for 24 number of this CIB, it comes to 2,40,000. As my lord has seen in the comparative statement, my lord. There it was rightly given, my lord. Now, therefore, my lord has seen the comparative statement, my lord. From this comparative statement, it is very clear that the private respondent has put more than rupees 2 lakhs. So therefore, since I win the lowest bidder, my lord, I put 2 crore 30 lakhs something. He put rupees 2 crore 50 lakhs, my lord. I have shown your lordship the difference also. It is precisely, my lord, it is given in my comparative statement, my lord. Let us watch my lord come to comparative statement, my lord. At page number 27 again, my lord. No, sorry, 29, my lord. So here, my lord, the tender authority, my lord. This is the document prepared by the department, my lord, the authority, my lord. Here, in fact, it has been rightly mentioned as 2 crore 50 lakhs 41,861. This is exactly the right figure, my lord, which ought to have been taken while considering all these tender bids document, my lord. How come, my lord, without any clarification from the private respondent, nor any corrigendum issued by the department, they could hold that no, the price as mentioned in this, his bid document is correct. So there is discrepancy, my lord. He has quoted rupees 10,000 for one number of this CIB. Despite that, in the last column, he has written that 24,000. Mistakenly, he has written that 24,000, my lord. If it is not a mistake, then also, my lord, the authority ought to have sought for this clarification from respondent number 3, my lord, private respondent. There is neither this clarification from the respondent nor any corrigendum, my lord, issued by the department. Without doing this basic requirement, my lord, how can the authority could declare that the respondent is the lowest bidder? That too, my lord, in the comparative statement, my lord, which is their own document, my lord, they have shown the petitioner to be the lowest bidder, my lord. So instead of this, my lord, they have awarded the work to the private respondent. That is why, my lord, I had, after detecting these discrepancies, my lord, I have written a complaint letter to Director, Rural Development. Then again, it was written on 31/1. Then thereafter, I have written a complaint letter to Secretary also of the RD department. Then again, my lord, despite this, my lord, my complaint, my lord, since even after the receipt of my complaint, neither the secretary nor the director had initiated anything, my lord. They just go ahead with this issuance of this LOA, then agreement. So therefore, my lord, from the face of the record itself, my lord, it is clear that there was a manipulation. And the letter of LOA agreement, whatever, my lord, subsequent letter issued in favor of the private respondent, it is illegal since, my lord, the very basis, my lord, which is the comparative statement, my lord, shows that there is discrepancies, anomalies. The authority could not have gone further. Rather, after proper scrutiny of both the bid document of both the parties, my lord, the authority ought to have awarded me the award. I being the lowest bidder, my lord. That is my case, my lord. Otherwise, there is some other anomalies Lordship. I will reserve this submission. I will make submission if they be needed, my lord. Let them submit first. My lord, only my document now, I am relying is the comparative statement, the bid document of the private respondent. From this document, I have demonstrated that they have committed illegalities, my lord.
Mayor, please come to page 26 now of the writ petition.
You are appearing for, respondent number?
Number 1 to 5.
1 to 5. Yes.
My lord, page 26, my lord, of the writ petition.
Yes.
My lord. May I please see the date, my lord? 11 December 2023. This is the board proceeding, my lord, in the district level. This is the minutes of the board, my lord. My lord, may I please see serial number 1, my lord. Pacho Enterprise. 2,13,000 to 26, 2 crore 13 lakhs 26,266. NK Enterprises, my lord. 2 crore 13 lakhs 27,346. Now, my lord, which one is the lowest bidding? Obviously, my lord, it is the, my lord, serial number 1. One is 2,13,026 or 2 crore 13 lakhs 26,000. One is 2 crore 13 lakhs 27,000. Now, my lord, this board proceeding was held at 11 December 2023, my lord, in the district board, in the district level, before the district board. Now, my lord, please come to my page 7 of my affidavit, my lord. Page 4, sorry, page. Sorry, yes, ma'am. Page 4, para 7, ma'am. Page 4.
Affidavit.
Yes, ma'am. Oh, by respondent number 1 to 5, ma'am.
Page number?
Page 4, ma'am.
Page 4.
Yes, ma'am.
Yes.
Para 7, ma'am. May I read, ma'am? That with regard to statement made in para 5 of the writ petition, deponent begs to state that all transparency was maintained during opening of financial bid held on 11/12/2023 in the district level. During opening of financial bid, all the bidders were allowed to cross-check and raise objections to bids of other bidders. At that moment of time, none of the bidders have made any objection to bid of other bidders. Accordingly, after following all due procedure, by board proceeding minutes dated so and so, the private respondent was conferred L1, my lord, and the petitioner was conferred L2. Since the conferment of L1 to private respondent was issued on 11/12/2023, my lord, there has been considerable delay in filing instead writ petition, as by now the tender work is about to be completed. Moreover, since during the proceeding of financial bid, the petitioner has not made any objection, thus by principle of acquiescence, the petitioner has no right to maintain instead writ petition, my lord. Now we are taking a plea of acquiescence, my lord. It happened on 11/12/2023, my lord. They never raised any objection, my lord. They were allowed to make cross-checking of the bid documents of the bidders, my lord, of their respective opponents, my lord. They did not challenge, my lord. They did not make any protest, my lord. And basing on that, my lord, we proceeded further, my lord. So, my lord, and that, my lord, this, my paragraph 7 statement, my lord, has not been controverted, my lord. They have not filed any reply, my lord. It is so we deemed to be admitted, my lord.
Now, my lord, what happened in thereafter, my lord? Now, again, my lord, this, my lord, in this page 26, my lord, it has been reflected, my lord, L1 was conferred to, my lord, Pacho Enterprise, private respondent, my lord, down below, my lord. Thus, the board recommended MS Pacho Enterprise was found to be lowest bidder and Ms. NK Enterprise as L2 bidders, my lord. So he did not protest, my lord. Now, page 99, my lord, or page 29 of the writ petition, 29, my lord, which they are heavily relying on, my lord. Page 29 of the writ petition, my lord. My lord, this document, my lord, is not part of the report, my lord. My lord, in this, my lord, comparative statement, my lord, no signature of the board has been reflected, my lord. Page 29, my lord, of the writ petition, my lord.
29.
Yes, 29, my lord. This is not the part of records. I have brought the original copies, my lord. I don't know how they have obtained this document, my lord. This is not part of the document. I will produce original document, my lord. I have it. And then, my lord, now what happened basing on this board proceeding, my lord? Basing on this board proceeding of the district level, the director level also held a board proceeding, my lord. That would be page 50, my lord, 50. Of my affidavit in opposition, my lord. Page 51 is the comparative statement, my lord. Technical scrutiny sheet, my lord, technical bit and financial bit, my lord. Here also, my lord, board, my lord, in the headquarter level has found the private respondent as L1, my lord, and the petitioner as L2. My lord, may see page 51, my lord. Same amount, my lord. Page 52, my lord, here, my lord, it has been recommended, my lord, MS Pacho as L1, the petitioner NK Enterprise as L2, my lord. Page 52, my lord. Recommendation, my lord. My lord, during this proceeding, my lord, during this entire exercise, my lord, there was no protest from the petitioner, my lord. Now, basing on that, my lord, on the two board proceeding, my lord, page 53, my lord, we have issued LOI to the private respondent. Page 53, my lord. This is LOI to the private respondent. Now, page 54, my lord. This LOI is of 8 January 2024, my lord. This date may be recorded, my lord. 8 January. Now, my lord, page 54, my lord. 10 January 2024, page 54, my lord. Letter of acceptance was issued in favor of the private respondent. Now, again, my lord, this is, my lord, page 54, my lord. Now, page 55, my lord. Supply order was also placed, my lord, 11/1/24, page 55, my lord. Again, my lord, page 56, my lord. This is the performance guarantee deposited by the private respondent, my lord. Page 56, my lord, on 12/1/2024, my lord. Now, page 57, my lord. This is the materials that has been asked by the authorities to the private respondent to supply of materials, my lord. This is of 15 January 2024, my lord. Now, page 58, my lord, annexure 8, my lord. This is the challenge submitted by the private respondent for supply of items, my lord. 17/1/24, my lord. After all, my lord, procedure was complete, my lord. Now, my lord, what happened, my lord? This petitioner, my lord, files a complaint, my lord. Submit a representation, my lord. That would be, my lord. Annexure 7 is page 66 of the writ petition, my lord, on 31/1/2024, my lord. After completion of tender work, my lord, everything was processed, my lord. 31/1/2024. For all the time, my lord, he was sleeping over, my lord, the petitioner. Now, after completion of tender works, my lord, after awarding of work, my lord, and performance of work, my lord, the petitioner, my lord, wakes up and files a complaint, my lord. Again, my lord, page 59 of my affidavit in opposition, my lord. Page 59, my lord. This is of 7 February 2024, my lord. Supply of materials, my lord, as sought by the authorities to the private respondent. 7 February, my lord. And then page 60, my lord. This is the supply items provided by the private respondent. What I am, my lord, projecting is that work is about to be completed, man. For in the entire tender process, they were sleeping. They never agitate, my lord. Now, after completion of tender process, now work has been executed. Now, it is about to be completed. Now they have filed writ petition, my lord. After so many, my lord, lapse of time, my lord. Now, my lord, this, my lord, private respondent, my lord. My lord, as per the affidavit of private respondent, my lord, for the period of March also, they have executed the work, my lord. Now, my lord, page 61, my lord, of my affidavit. They have not been left unattended, my lord. They have been issued with the work, my lord, for other CD block, my lord, page 61, my lord, of the same district, my lord, page 61, my lord. This is a letter of intent so and so for Surly CD block, my lord, of district Kurunkumen. This is in respect to one same district, my lord. Now for another CD block, my lord, he has been given work, my lord. This is the LOI, my lord. Page 61 is the LOI given to the petitioner, my lord. And
My lord,
page 64, my lord, page 64, let me complete, my lord. Page 64 is the MOU, my lord. Memorandum of Agreement, my lord, with the petitioner, my lord. Again, my lord, another block, my lord, page 67, my lord. Page 67 is the supply order, my lord, issued to the private respondent for Surly CD block, my lord. Page 68, my lord, is the LOI issued in respect of Polosang CD block, my lord. Type copy is at page 69, my lord. What I am submitting is, my lord, he has been not left unattended, my lord. He has been given work, my lord, for 2 CD blocks, my lord. Page 69, my lord, this is with respect to Polosang CD block, my lord. 69 is the type copy, my lord. This both amounts, my lord, for Surly CD block, he has been awarded a work of rupees 1 crore 77 lakhs 11,608 And for Polosang CD block, he has been awarded work of rupees 1,41,89,286, my lord. My lord, the tender authority, my lord, have exercised their, my lord, the scrutiny, my lord, basing on the amount quoted by the bidders, my lord. So basing on the amount quoted by, not by the rate, my lord. Basing on the amount quoted by the bidders, my lord, they have been given respective L1, L2, my lord. Now, this community, my lord, block, my lord, this CIB, my lord, Community Information Board, my lord. What is this, my lord? Now, this is a board, signboard, my lord, indicating the place of area, my lord. This area belongs to this village. This area goes to this direction of the village, my lord. This is only the Community Information Board, my lord. So I have asked the authorities, my lord, they are saying that the private respondent, he has to execute the work as per the amount quoted by him. So he has to, my lord, erect a CIB, my lord, basing on his rate quoted by him, my lord. Now, my lord, sole case of this defense, my lord, is that, my lord, they have been sleeping over their right, my lord. So law of accusations comes into play, my lord. For that, my lord, I would like to lay some judgment, my lord. Before that, my lord, this is the original record, my lord. And this is the bid of the bidders, my lord, private respondent and the petitioner, my lord. I have flagged it, my lord. My lord, I would like to rely on some judgment. Yes, my lord. 2022, 2 SSC. 2022, 2 SSC, 301, my lord. Paragraph 39 and 40, my lord. May I read, my lord? Yes, paragraph 39, my lord. Before proceeding further, it is important to clarify distinction between acquiescence and delay and laches. Doctrine of acquiescence is an equitable doctrine which applies when a party having a right stands by and sees another dealing in a manner inconsistent with the right, while the act is in progress and after violation is completed, which conduct reflects his assent and accord. Paragraph 39.
39.
Yes, 39.
Yes. Yes.
Yes, Lord. May I read again?
Mhm.
Before proceeding further, it is important to clarify distinction between acquiescence and delay and laches. Doctrine of acquiescence is an equitable doctrine which applies when a party having a right stands by and sees another dealing with in a manner inconsistent with the right while the act is in progress and after violation is completed, which conduct reflects his assent and accord. He cannot afterwards complain. In literal sense, the term acquiescence means silent assent, tacit consent, concurrence, and acceptance, which denotes conduct that is evidence of an intention of a party to abandon an equitable right, and also to denote conduct from which another party will be justified in interfering with such an intention. Acquiescence can be either direct with full knowledge and express approbation, or indirect where a person having the right to set aside the action stands by and sees another dealing in a manner inconsistent with the right and in spite of imprisonments takes no action mirroring acceptance. However, acquiescence will not apply if lapse of time is of no importance or consequences. Paragraph 41. Laches, unlike limitation, is flexible. However, both limitation and laches destroy the remedy but not the right. Laches, like acquiescence, is based upon equitable considerations, but laches, unlike acquiescence, imports even simple passivity. On the other hand, acquiescence implies active assent and is based upon the rule of estoppel in pace. As a form of estoppel, it bars a party afterwards from complaining of the violation of the right. Even indirect acquiescence implies almost active consent, which is not to be inferred by mere silence or inaction which involved in laches. Acquiescence in this manner is quite distinct from delay. Acquiescence virtually destroys the right of the person. Given the opposite legal position, inactive acquiescence on the part of the respondent can be inferred till the filing of the appeal and not for the period for filing of the appeal. Nevertheless, this acquiescence being in the nature of estoppel bars the respondent from claiming violation of the right of fair representation. My lord. On my lord, since in my para 4, I have stated, my lord, they have not raised any objection during scrutiny, my lord. And in the director level also during scrutiny, they have not made any objection. My lord. Now, after awarding of work, after execution of work, they have filed a complaint. My lord. Now, my lord, since my lord, I have also, my lord, stated in my para 4 that there was the bidders were given opportunity to place objection on it against each other's, my lord. So they have not made any objection, my lord. And it has not been controverted, my lord, by the petitioner, my lord. I would like to relate 2020 5 GLT 361, my lord. Para 14, my lord.
40?
14, 1-4. Merit, man. In the case of Nasim Banu versus State of UP versus so and so, 1993 Supply 4 SSC 46, the FX court has held that averments are deemed to be admitted if not controverted. Para 14. Yes.
Yes,
Yes, ma'am. As the petitioners have not controverted the affidavit in opposition of the state respondents, wherein it has been stated that the funds of the TFC has been used for the projects, this court does not find any reason to direct any investigation by a special investigation team into the allotment of the project's contract works, as there does not appear to be no loss caused to the public exchequer, as the projects appear to have been duly executed. In view of the reasons stated above, we are not inclined to exercise our discretion under Article 226 of Constitution of India. In this case, PL is accordingly dismissed. And my lord, I would like to relay some other judgment. My lord. 2022 6 SSC, my lord. Page 127, my lord. My lord, para 23, my lord. (127), paragraph 23. Lord.
Twenty-three.
23, my lord.
Okay, okay. Yeah.
Yes, may I read, my lord? In view of the above judgments of this court, the writ court should refrain itself from imposing its decision over the decision of the employer as to whether or not to accept the bid of a tender. The court does not have the expertise to examine the terms and conditions of the present-day economic activities of the state, and these limitations should be kept in view. Courts should be even more reluctant in interfering with the contracts involving the technical issues, as there is requirement of the necessary expertise to adjudicate upon such issues. The approach of the court should be not to find fault with magnifying glass in its hand. Rather, the court should examine as to whether the decision-making process is after complying with the procedure contemplated by the tender conditions. If the court finds that there is a total arbitrariness or that the tender has been granted in a malified manner, still the court should refrain from interfering in the grant of tender, but instead relegate the parties to seek damages for the wrongful exclusion rather than to inject the execution of the contract. The injunction or interference in the tender leads to additional costs on the state and is also against public interest. Therefore, the state and its citizens suffer twice, firstly by paying escalation costs and secondly by being deprived of the infrastructure for which the present day government are expected to work on. So they have the remedy to approach civil court, my lord, if they are really aggrieved, my lord. My lord, this is the last judgment I would like to refer, my lord. Year 2023. This is Tata Motors, my lord, limited. Yes, my lord. Para 54, my lord.
Para?
54, 54. My lord. Page 2717, my lord. Yeah. AIR 2023 SC 2717.
2717,
Yes,
para
ma'am.
24 you're saying?
Para 54, ma'am. 5, yes.
Yes.
Ma'am. Mary, ma'am.
Hmm.
As observed by this court in Jagdish Mandal versus State of Orissa and others so and so, that while invoking power of judicial review in matters as to tenders or award of contracts, certain special features should be borne in mind that evaluations of tenders and awarding of contracts are essentially commercial functions, and principles of equity and natural justice stay at a distance in such matter. If the decisions relating to the award of contract is bona fide and is in public interest, court will not interfere by exercising powers of judicial review, even if a procedural aberration or error in assessment, error in assessment or prejudice to a tender is made out. Power of judicial review will not be invoked to protect private interests at the cost of public interest or to decide contractual disputes. This judgment says, even if there is some error in assessment, court should not interfere. So basically, the law of acquisitions comes into play in this case, because since 11 December 2023, till finalization of the tender, they have not placed any objection, They were given opportunity. They have not made any objection, So law of acquisitions comes into play, Even our statement has not been controverted by the petitioner, They were not given opportunity, They were given opportunity for objection, And regarding this document, page 29, it is nowhere in the original document, I don't know how they have obtained this, Original I have placed, And there has been no, manipulation of the records, The bid quoted by the bidders are as it is, That, no. My lord, may I please peruse the records, original records, I have flagged it, blue file, yes, I have flagged it,
Yes.
First takes are regarding the board proceeding, And the last take, is the board proceeding of the district board, Last part of the take, flag, which I have flagged. On the top, my lord will see Damin, Damin city below.
Yes.
This page 29 does not have any relevance, It is not in the record, original record, This page 29 also does not bear the signature of board members, No board members have signed. Right. On the top, my lord, I see, my lord. I may, excuse.
No, I have seen board proceedings. and-
Yes, sir, district board proceeding. Yes, yes. Mal, obliged.
May I submit? My lord, I am making, my lord, a 3-point argument, my lord. Pass my submission, my lord, is this writ petition, my lord, is not maintainable, my lord. Second, my lord, even if maintainable, my lord, this my writ petition, my lord, liable to be dismissed, my lord, without going into the merit, my lord, as they has misrepresented, my lord, while filing this writ petition, my lord. Third, my lord, assuming the writ petition, my lord, is correct, my lord. Then also, my lord, at this stage, my lord, what would be remedy, my lord. So I will start with my first argument, my lord. How this writ petition, my lord, would be not maintainable, my lord. My lord, can you take up my affidavit in opposition, my lord? My affidavit in opposition, my lord, page number 15, my lord, 15 annexation number A, my lord. This is, my lord, earlier writ petition, my lord, filed by the petitioner, my lord. Writ petitioner 62. And now prayer part, my lord, will kindly turn, my lord. Prayer, my lord. Prayer part, my lord, they has, my lord. A prayer, my lord, will see at page number 28, my lord.
Just a second. You are 4 to 6.
I for 6, my lord. Epidemic in opposition filed by respondent number
You are respondent number 4 to 6.
No, my lord, 6, my lord, 6 only. I am private respondent. my lord.
Just a 6. Yes.
6, my lord. My lord will annexation number A, my lord, starting from page number 15 is the writ petition, my lord, filed by the present petitioner, my lord. Now, prayer part, my lord, will see at page number 28, my lord. Page number 28, my lord.
Yes.
28 down below, my lord, will see down, prayer part down below, my lord. 1, my lord, such and such, quashing the impugn board proceeding minute dated 11/12/2023, my lord. This is the past prayer, my lord. Thereafter, my lord, the impugn letter next page 10, my lord. The acceptance dated 10/1/2024, my lord. Issued to the respondent number 6, my lord. And thereafter, an impugn agreement dated 11/1/2024, my lord. This 3 prayer were made, my lord. Now, my lord, kindly turn to page number 33, my lord. This is annexation number B, my lord. This is the order passed, my lord. The operative part is at page number 35, my lord. My lord. Now, my lord, will see, my lord, 35, my lord. This is order dated 10/19/2020, and her such and such, but the petition submitted. He has instruction to withdraw a writ petition, my lord. Writ petition is accordingly disposed as withdraw, my lord. And my lord will say, my lord, no liberty was sought, my lord. No liberty was sought to agitate those, my lord, those documents, my lord, which was challenged under this writ petition, my lord. Now, how subsequently, my lord, without any liberty of this court, my lord, they can again agitate, my lord, in a new petition, my lord. Now, to that extent, my lord, issue, my lord, has I rely on judgment, my lord, how this is written. This is, my lord, 2019 5 GA 732, my lord. Issue my page, I am relying para 6, 7, and 8, my lord. I read short part only, my lord, not also. 6, having note the decision of Supreme Court, this, my lord, this is the decision rely in this is Sir Guruja Transport Service versus State of Transport Appellate Tribunal, Madhya Pradesh and Gaylord and others, 1981 SCC 5, my lord. I will skip other part, my lord. Here, my lord, my lord will kindly page number 5, my lord. 5, my lord. 5, page number 5, my lord. 9, my lord. This is para 9 of the Supreme Court judgment, my lord. I am reading, my lord. Para 9 of Supreme Court judgment. The point of consideration is whether a petitioner, after withdrawing a writ petition filed by him in a High Court under Article 226 of the Constitution of India, without the permission to institute a press petition, can file a press writ petition in High Court under that article. On this point, the decision in Darayao's case supra is of no assistance. But we of the view that the principle underlying Rule 1 of the Order 23 of the court could be extended in the interest of the administration justice to case of withdrawal of writ petition also. Not on the ground of res judicata, but on the ground of the public policy as explained above. It would also discourage the litigant from indulging in the bench hunting technique. In any event, there is no justification reason in such case to permit a petitioner to invoke the extraordinary jurisdiction of High Court under Article 210 Constitution once again, by law. Thereafter, relying on this judgment, my lord, directly, my lord, I will skip other part, my lord. This is 7, my lord, of this region, my lord. Issue which is posted in Sarguja's transfer service was the effect of withdrawal of the writ petition filed under Article 226 of Constitution in without permission of the High Court to file a press petition. The Honorable Court, after having framed the question as to whether the petitioner, after withdrawing a writ petition filed by him in the High Court under Article 226 of the Constitution of India without permission to institute press petition, can file a press petition in High Court under the article after consideration of consideration provision of law as quoted here in above, has held that press petition is non-maintainable in respect of same subject matter if the earlier writ petition has been withdrawn without permission to file a writ petition. In this case, undisputed, my lord, all 3 issues, my lord. My letter agreement, my lord, all the board proceedings challenge, my lord. That was.
But as per him, most probably the supply of the order was not put to challenge in that earlier.
Yes, it's true. Now, that way, my lord, if my lord, that way, this supply order, my lord, will truly, that is consequential order of supply order, my lord. Now, now at this stage, my lord, in second petition, my lord, this supply order, my lord, my lord, board proceeding, agreement, my lord, those cannot be changed without liberty, my lord. Now, this supply order, my lord, is consequential of this order, my lord. Now, until and until this order being challenged, this supply order cannot be challenged in this writ petition also, my lord. This is consequential order only, my lord. Now, second, my lord, for second, my lord, for the Mopin, my lord, will kindly take up a writ petition, my lord, for a Mopin, my lord. My lord will kindly see at page number 26, my lord. Page number 26, my lord.
Yes.
If my lord see this is page number 26, my lord, down below, this is 1, 2, 3, 7 member board, my lord. All the signature is there, my lord. Now here, my lord, undisputedly, I am the L1, my lord. My lord, I am the L1, my lord. By this, my lord. I am L1, my lord. My margin is 1,000 and my lord, I am his my lord quoted that is petition quoted higher than 1,790.2 point by me, my lord. Now this proceeding, this my lord is seen, my lord. Next, my lord will kindly see, my lord, at page number, my lord. Suppose my lord will see a page number 30, my lord. Page number 30, my lord. Now here, page number 30, my lord. Here also, my lord, will see, my lord, down below, my lord, there is a signature of joint director, my lord. In the opposition, there is a, this is not legible, but there is signature of one person also, my lord, official person, my lord. This is, this is document submitted in me. Yes, this is official record, my lord. There is signature of all those officers, my lord. And this applicable to page no other page also, my lord. Now, for document, my lord, kindly turn to page number 28 and 29, my lord. Now, this is the documents, my lord, by relying whole his case, my lord, case of the petitioner, my lord, are heavily relying on this document, page number 28 and 29, my lord. Now, my lord will kindly see page number 28, my lord. Here, my lord, and 29, my lord.
there is signature of only assistant project officer, my lord. In joint director, my lord, there is no signature, my lord. 28, 29, 29 also, my lord. They are saying this is comparative, my lord. Here also, my lord, there is no signature, extras, my lord. Now, to this extent, my lord, I have made a categorical statement, my lord. I have made a categorical statement in my affidavit in opposition, my lord. I have made a category in this regard, my lord. I have made a categorical statement in my para 8 and 9, my lord. I have made categorical statement that, my lord, these documents, my lord, is not the part of the whole tender process. This was prepared, my lord, and manufactured by the one officer, my lord, to make a case for the petitioner, my lord. I have made category statement for my para 8 and 9, my lord. 8 and 9, my lord. Just to favor the petitioner, my lord, he manufactured, my lord, this officer, my lord, APO, my lord, of the manufacturer just to favor petitioner. Now, this allegation, my statement, my lord, category statement, my lord, had never been replied by the petitioner, my lord. Not replied by the petitioner. Now, if that is not replied, my lord, no, my lord, it is deemed admission, my lord. Now, this is admitted fake, my lord. This is my statement is true, my lord, as they have not revived this, my lord. Therefore, my lord, their whole petition, my lord, is based on misrepresentation, my lord, and fraud, my lord. When the case is based on misrepresentation and fraud, my lord, this is never rebutted, my lord. In such situation, my lord, Supreme Court say, my lord, the High Court, my lord, while exercising the Article 226, my lord, not need to go into the merit of the case, my lord. The writ petition, my lord, when based on the fraud and misrepresentation, my lord, liable to dismiss in limine, my lord. So that extent, my lord, I am relying on this, my lord. Other as part only para 1, I have indicated the para, my lord, relevant para, my lord, but at para 24, my lord. The jurisdiction of Supreme Court under Article 21 and 32 and High Court under 226 of Constitution. Sorry, my lord, at para 24, my lord.
Page 24, para 24?
Para 24, my lord. Other, though I have indicated other para, my lord, I will not read it. On 24, I am reading, my lord. Under 226 of Constitution is extraordinary, equitable, and discretionary. Prerogative writ mentioned herein are issue for doing substantial justice. It is therefore of utmost necessity that the petitioner approaching the writ court must come with clean hand, put forward all the facts before the court without concealing any or suppressing anything, and seek an appropriate relief. If there is no candid disclosure of the relevant and material fact, or the petitioner is guilty of misleading the court, his petition may be dismissed at the threshold without considering the merit of the claim, my lord. So my humble submission, my lord, is, my lord, my allegation that, my lord, those two documents in which petitioner heavily rely, my lord, as manufacturer by one officer, my lord, to make out a case for in their favor, my lord, and that statement, my statement, my lord, categorical statement at para 8 and 9 has been never reversed by the petitioner, my lord. That become admission, my lord. In such situation, my lord, this writ petition, my lord, is liable to be dismissed, my lord, going immediately to the case, my lord. Third, my lord, point I am reading, my lord, already submitted by my friend, my lord. Now, situation, my lord, here is, my lord. My lord, connection, my lord, those tender process, I participate, my lord. Even if assuming there is some wrong in calculation, my lord. Assuming wrong in LS petition, my lord. Then also, my lord, I was awarded, my lord. Petitioner never said, my lord, I was part of that wrong, my lord, committed by the respondent, my lord. I was awarded the work, my lord. I have supplied now I have supplied the whole item, my lord. Now all has been completed, my lord. In such situation, my lord, whether this, my lord, is appropriate, my lord, case, my lord, for evoking extraordinary jurisdiction, my lord. Now, my lord, all my learned friend, my lord, standing council has already relied, my lord, the Tata Silvera, my lord. Say, my lord, in such a time, even if say arbitrary, my lord, in the public interest, my lord, the appropriate remedy, my lord, would be civil, my lord. It is not the case that petition no remedy, my lord. But at this stage, my lord, without my wrong, my lord, any order, my lord, pass is against me. I will be the victim, my lord. I have invested all my hard-earned money, my lord. I have supplied hard work, my lord. I have completed that work, my lord. At this stage, my lord, my humble submission, my lord, any interference, my lord, would be my lord, seriously prejudiced to me. That the limited submission I made. Obvious.
My lord, all the judgment placed by the London Standing Council for the department does not at all have any relevance with the instant case, because he's talking about delay in laces. There was no delay in laces at all. In the very first, I had made the submission that after obtaining the document from RTI, I cross-checked both the document. They took some time. My lord, may kindly say, my complaint to the director RD was 31 January, my lord. Just after lodging the complaint, filing the complaint, I cannot approach this honorable court, my lord. I was expecting the response from the authority. In fact, this honorable, before this exhausting alternative remedy, my lord, I could not approach this honorable court. So we cannot expect the petitioner to be too prompt to approach the honorable court without exhausting the alternative remedy, my lord. So therefore, after comparing the statement, be documented both the parties, I rightly approached the right person, my lord. It is the director RD who is the right person to address my grievances, my lord. Even if today this honorable court admit my writ petition, allow my writ petition, this honorable court will be directing the director RD department to address my grievances, my lord. So therefore, there is no delay in license, because just after lodging the complaint, my lord, I was expecting that my grievances will be addressed by the competent authority, my lord. Now my lord has seen. Even after this submission of lodging of the complaint, my lord, the director, he did not do anything. Till today, he hasn't done anything, my lord. When he did not address my grievances, my lord, I had to write a complaint to Secretary RD Department, my lord, on 5th February, my lord. That, my lord, I have annexed my complaint letter in my writ petition, my lord. My lord has seen my complaint letter, my lord. My lord, may kindly come to page number 66. This is the complaint written to Director, my lord, RD Department, my lord, on 31st January 2023, my lord, 24. When he did not address my grievances, my lord, I had to write another letter to the secretary, my lord, who is the controlling officer of the director, my lord. That is on 5/2/2024, my lord. My lord, it's not that, my lord, just after detecting the complaint, I kept quiet, my lord. I approached the appropriate authority, my lord. When they did not initiate anything on my complaint, then only, my lord, I had to come to this honorable court. So therefore, there is a, my lord, the chain of the steps, my lord, taken by the petitioner is not, my lord, broken anywhere, my lord. Now, my lord, my plan has, I am very, in fact, very, it's surprising to know, my lord, that this document, my lord has seen, my lord, I have applied to RTI, my lord. There in the office, my lord, in every office, my lord, every department, only one, this PIO is appointed, my lord, Public Information Officer. who will be handling this supply of the document to the applicant, my lord. There, in a department, my lord, in every department, only one PIO is appointed. So, my lord, this is the person, my lord, right person. My lord has seen. My lord, now the petitioner, the department, the authority, and the private respondent, they are making an excuse, my lord. My lord can see, my lord. This page number 27, my lord. Once again, my lord, come to this page number 27, my lord, of my writ petition, my lord. My lord can clearly see, this is Arunachal Pradesh Office of the Project Director, District Rural Development Agency, Kurung Kumai District, Koloriang, my lord. This is APO, assistant, yes, this is APO, this document was issued by APO. Now, this letter was, my lord, if at all, is assuming that, not admitting, but assuming that this document has been created to favor my case, is submitted by the counsel for the private respondent. My lord, this document was, a copy of this document was also this furnished to Director RD, my lord. My lord, below this the letter, my lord. Copy was furnished to Director RD, my lord. Sri Bengiat, the APO, also Sri Seran Yogati. These people were also served the copy of this reply, which this letter, of course, it was served to me, and copy of this document was served to these people, my lord. And my lord, next page, my lord. Assistant project. This is the document, my lord, issued by the PIO of the department, my lord, to the petitioner. Now, my lord, if at all the submission made by the private respondent that this document has been manufactured, if at all this is manufactured by any of the officers of the department, my lord, to favor my case, did they take any action, legal action, whatever, departmental, whatever, against this person who has this furnished this document to the petitioner, my lord? Just saying that the officer concerned, particular officer has issued this letter to the petitioner to favor the case of the petitioner will not substantiate, my lord. They are not handicapped, my lord. The person who has issued this letter is just APO, assistant project officer. Above him, there is director, my lord. Secretary is there, my lord. If I had really manufactured this document to support the petitioner, I mean that particular officer, all the departments see like that ideally, my lord? Not at all, my lord. Therefore, without substantiating anything, my lord, just saying that this document on which I am relying over is a false document, manufactured document, then, my lord, that is not in fact acceptable. If at all it has been manufactured, forced, created for the purpose of this favoring the petitioner, my lord, department would not sit idly like that, my lord. They would have initiated proper action against me. Oh, sorry, against this person who has furnished this letter to the petitioner, my lord. Now, even I have written the complaint, my lord, in my complaint letter to the director, my lord. My lord, may kindly see the contents of my complaint, my lord. I have clearly mentioned in my complaint that there is illegalities. My lord, may kindly again come to page number. I had to burden you, my lord, because, my lord, this fact that the fact this particular document has been manufactured, my lord. It cannot help to be true, my lord. If at all there is some this illegalities on the part of this particular person, officer, to have created this particular document to support my case, they would not have sit idly like that, my lord. That is for sure, my lord. Every concerned person will think about it. Now, my lord, kindly once again come to
Page two,
page number 66, my lord. My lord, just address is on the top is there to the director, my lord, and my contention, my lord, it is numbered as 1, 2, 3, my lord. My lord, we start from this serial number 1, my lord. That age estimate amount put for tender was rupees so, my lord. That as per technical sanction copy received through RTI, it is revealed that MS Paso Enterprise offered rupees 2,15,000. 15 lakhs 41,861. Sorry, 816. So and so. And my firm, NK Enterprise, offered rupees 2 crore 13 lakhs 27,000. So and so. So, my lord, this fact was brought to the knowledge of the my lord director on 31 January 2024, my lord. Even today, I am expecting some response from this director, my lord. But instead of taking over this, addressing my grievances, my lord, if at all, my lord, if this person, the officer concerned, my lord, whom they are this alleging that this particular document has been manufactured or created by this particular official, my lord. In my complaint, my lord, it has been clearly written, my lord, as per the comparative statement, the amount what I have offered, my lord, it is so and so, and the amount what he has offered, it is so and so, my lord. From this complaint letter, my lord, if at all this comparative statement, copy of the comparative statement which have been furnished to me by this KIO, my lord, if it is a fake one, my lord, basing on my complaint, my lord, there could have been an inquiry against that particular officer, my lord. Till today, they are not saying anything, my lord. No action is being taken against any officer. So therefore, claiming that this particular document has been manufactured, it is totally incorrect, my lord. It cannot be believed at all. Had they taken any action against the officer, my lord, concerned, we could have believed, my lord. Now, my lord.
As per them, your petition page number, I forgot. They have annexed 26 or 27.
Yes, my lord.
There's a signature of the other, the board members were not there, except.
This is the, my lord, document issued by the PIO, my lord. Those person who is issuing the document only will put his signature, my lord. Because I am just seeking the document, my lord. So person who PIO concerned will put his signature. Now, my lord, regarding this rest of the work, as my learned friend, who is the standing counsel of the department, my lord, he has shown some work order issued to the petitioner, my lord. In fact, my lord, the firm is same, my lord. Firm is same, but here in the instant case, my lord, I have participated in the tender process as a power of attorney, my lord. For that particular work, I was given the power of attorney, my lord. Rest of the work, my lord, which my friend has referred, is being carried out by the proprietor himself, my lord. So therefore, the work, the other works, my lord, that has been awarded is being carried out by the proprietor, my lord. Here in this case, my lord, I on behalf of this power of attorney only, my lord. I had participated in the tender process. And if it was awarded to me, my lord, I would have carried out the work, not the proprietor, my lord. Whatever the profits I would have earned, it would have been received by me only, my lord, not by the proprietor. So therefore, the rest of the works, my lord, what my friend has referred, it has no nexus with the present petitioner. It has got nothing to do with the present petitioner. Those work are being carried out by the proprietor himself, my lord. So therefore, this awarding of the work to the proprietor, my lord, that makes any difference, my lord. Now, regarding this, my lord, although while this withdrawing the writ petition, my lord, yes, of course, the petitioner could not seek for this liberty, my lord. But then, when the matter was taken up in the motion itself, my lord, my friend has fleshed that order, my lord, the work order, my lord. Then this honorable court view was that no, since the petitioner has not challenged that work order, anything that will be passed in this writ petition will have no effect on that work order. So therefore, I clearly submit that the petitioner had withdrawn the writ petition. But while withdrawing, he forgot to this support this liberty, my lord. But in any case, my lord, this issuance of this supply order is a press cause of action, my lord. On that basis, always the petitioner had the right.
It is the subsequent to that order, in fact.
Yes,
The
yes.
supply was done. Because in your petition, writ petition, there were the prayer which were made.
Yes, ma'am.
And the supply order subsequent, which has been done by the subsequent order.
Yes,
to
but
supply.
yes.
But as per them, it is the subsequent order in connection with that allotment order, in fact.
Yes, that is the, of course, my lord, that is the consequential order, my lord. But the honorable court view is that even if this honorable court stays the operation of this agreement and then AO, then but since this is not put to challenge that supply order, he can go ahead with the supplying of the material, my lord. It was the view of this honorable court. That is why, my lord, the petitioner has withdrawn the writ petition, and immediately after withdrawal of the writ petition, this instant writ petition has been filed, my lord. And my lord, when the present writ petitioner was filed, my lord, on the motion, my lord, the petitioner prayed for the granting of interim relief, my lord. It was not granted, my lord. So the writ petitioner prepared writ appeal, my lord. In the writ appeal, my lord, the interim order was granted to the petitioner. That was stayed all these orders. My lord, here is the order, my lord. Then thereafter, this on the admission stage itself, this writ appeal was disposed of, my lord, while granting this interim order. So the writ petition, this present writ petition, while disposing of the writ petition, as this instant writ petition was listed in the next coming few days, my lord. So after granting that interim order, that writ appeal was disposed of, and now here in this writ petition also, my lord, this honorable court has granted interim order, my lord. If at all, my lord, now, my lord, say just submitting that, my lord, see, this writ petition was filed on, my lord, can see, my lord. My lord, yes. On 17/3, my lord. Sorry, my lord, it was filed on 14th February, my lord, 14th February. And this honorable court has granted this interim order for directing the parties to maintain status quo, my lord. By that time, my lord, by that time, there was no supply of the item, my lord. Although the supply order is issued, but since there was a stay order from the division bench, then thereafter there was an interim order in this writ petition also. So if there is no supply of this of the material, my lord, if at all they have now, if they are saying that all the supply has been done, then my lord, they have committed this contempt, my lord. During the operation of this stay order, my lord, if they have supplied the order, my lord, this material, my lord. My lord, on their admission, my lord may take up this proceed to sumo to a contempt case, my lord. Against.
My lord, sorry, my lord, that is a wrong and my lord, new submission, my lord. My lord, will kindly see it my page on 37, my lord. Past supply order was on 7, I supply on 17/1/2024, my lord. This is new submission, my lord, and wrong submission, my lord. That should not be, my lord. And second, I have submit page number 40, my lord, 2/2/2024, my lord. This is wrong submission, my lord. In my opinion, opposition, my lord, I have enclosed the supply order also, my lord. This, sorry, my lord, that is wrong submission on the part of my lord. Page 36, my lord, I have past supply order was issued on me on 11/1/2024, my lord. I supply that, comply that order on my lord. Next page number 37, my lord. 17/1/2024, my lord. And second supply order was issued to me on 7 February 2024, my lord. And
First supply order was issued on? First supply order was?
11/1/2024, my lord. Page number 36, my lord. Second, my lord was on 7 February 2024, my lord. And I supplied that on 12/2/2024, my lord. And third, my lord, I have supplied on 16/2/2024, my lord. At that point of time, my lord, interim order by division bench, my lord, was not continue as a single bench, my lord. Single bench declined to continue the interim order, my lord. After final order by the division bench, my lord.
And my lord,
It is a wrong submission, my lord.
and my lord, I would like to clarify this page 29. Page 29 of the writ petition, my lord. From the report, I would correct it, of the writ, page 29. my lord. Yes, my lord has seen page 29 down below, 27/12/2023. Signature, my lord. My lord, I have flagged it, my lord. All the bid documents, original documents were forwarded before the directorate on 12/12/2023, my lord. It is there on the top, my lord. Yes, my lord. Damin CD block is also there.
Yes.
Package number 1 is Damin CD block, my lord. It was forwarded on 12/12/2023 before the directorate, my lord. By that time, the district board has no bid documents with them, my lord. So how this documents has come into existence, my lord? Page 29, my lord. After forwarding of all original documents before the directorate, my lord, this documents has been given to the petitioner, my lord.
Yeah, I have heard.
My lord, the signatures of the private economy, my lord. It can, you can see that my lord, this document also can be manufactured, my lord. In my repetition, my lord, page number 75, my lord. Down below, my lord, the signature of the private economy is different, my lord. In the tender bid, my lord, the signature is different, my lord. Even in the agreement, my lord, the definition is different. So therefore, my lord, I am not the custodian of this document, my lord. I cannot manufacture, my lord. They are the custodian. My lord, the department has produced the original record, my lord. In the original record, it is very surprising to see that the document is annexed. The file already filed, or whatever the record is under the custody of the department manager. My lord, cannot understand my lord. I don't understand because it is not in my lord, it is not my within my domain. It is beyond my reach. I cannot manufacture all these documents. They are manufacturing this document not issued by the department. They are only blaming the officer of the department. Only blaming will not do matter. Action matter. It is a particular officer against done wrong, committed wrong. There is nothing that's happening. We cannot now the department cannot deny that the communities for development. The delineation of this document cannot be issued. Please not there in the original department. Please, here is in the original record said by how
As per them, those were manufactured by you. You mean in a sense with the some of the officials.
Yes, my lord.
That's why the documents which you have, furnished
My
are
lord.
not available in the original. Original says something.
Yes.
That is as per them.
Yes, per them. My lord, that is what my lord. This in fact requires very deep and this investigation. In fact, my lord, this is in fact economic offense, my lord. If such type kind of this mismanagement in the department is allowed, my lord. My lord can see this document. They are not saying that I have manufactured. They are saying that their officer has manufactured it. But despite that, they are not taking any action against the officer, my lord. Is there no any connivance, my lord, in between them, all the parties, my lord, the private respondent and the officers, my lord. This is the document. After this, my lord, I have ventilated my grievances before the appropriate authority, who is the director of the RD department, my lord. Way back in this 31 January 2024, my lord. Today it is June, my lord. 7 months passed, my lord. Still they are sitting idly over my complaint, my lord. In my complaint, I have mentioned about this letter, my lord. They are doing nothing, my lord. What they are submitting before this honorable court is just, my lord, is a statement trying to mislead this honorable court. I am surprised, my lord. They are saying that this document is not in the original file, but they are it is within their knowledge that this document has been issued by their officer, but still they are keeping quiet. They are taking neither addressing my grievances, nor taking any action against the officer, whom they are alleging of this committing this mischief. So therefore, my lord, on the basis of this document, my lord, this document is a correct document, my lord. And from the document supplied, it is they are not denying, my lord, with this bid document. In the bid document, my lord, I have demonstrated, my lord. The private respondent has quoted 10,000 for the CIB, my lord. They are not denying that. Neither the private respondent nor the department. They are not denying that the private respondent has quoted 10,000 for this one number of CIB, my lord. If the total quantity is 24, my lord, and if he is offering 10,000 for one number of CIB,
Obviously, it will come to
yes, it will come to 2,40,000. But in order to accommodate private respondent number 6, my lord, they have intensely brought down the total amount, my lord, to 2,13,000. Only if that amount is taken to be true, I am just 1,000, I have got just 1,000 rupees more than the private respondent. But this figure of 2,40,000 is to be taken as the genuine offer rate by the private respondent. Then, my lord, he has quoted higher than the petitioner, my lord. And that higher quoted amount is more than 2 lakhs, my lord. My lord has seen that. Now, the fate of the case, my lord, it is this document only. The comparative statement, my lord. Now, to oust me from the rest of this, getting this award, the work awarded, my lord, they are just saying that this letter might have been, this document might have been created or manufactured by the officer, my lord. This vague statement will not substantiate, my lord. They have to substantiate that because that particular officer has created this document, so therefore department has initiated some proceeding against that particular erring officer, my lord. There is nothing as such, my lord. So therefore, there is no reason why this document should not be taken as genuine, my lord. So therefore, if this document is to be taken genuine, my lord, obviously the petitioner has quoted lower than the respondent, my lord. So if I have quoted lower price, my lord, then he has to go. I have to come in, my lord. And regarding the completion of the work, my lord, as I have already shown, my lord, there is interim order, my lord. Even if there is no interim order, my lord, suppose, even if there is no interim order, they have come to knowledge that I have challenged entire order, work order, agreement, everything, my lord. They are in this, my lord. I have established, there is a very good ground to establish my case before this honorable court. So, despite having the if this supply are made, my lord, GPM is, my lord, Gram Panchayat member. It will be informed to them. It is necessary to inform to them. So all the GPM, there's not in receipt of all the material, my lord. So therefore, they went today, my lord, to my lord, this receive the, my lord, some liberal view of this honorable court. Only they are making a submission that they have supplied the this material, my lord. In fact, in the ground, they have not yet, my lord.
Okay. Make it a series. You're keeping it as a CV?
My
Or
lord,
is it-
my lord.